difference between a domestic asset protection versus an offshore asset protection strategy?
Okay. You only give me,
You got
give
to
me
answer
5
30
minutes.
seconds.
In 5 minutes, or let's explain this. Okay. So a big part of our practice is asset protection, or just wealth preservation. How do you protect your assets from the claims of third-party creditors, predators, liens, judgment holders, your creditors, your wife's creditors, your kids' creditors, inheritance, business creditors, etc. And so there are a lot of people familiar with the uses of LLCs. We've already mentioned those. You can use corporations. These are all limited liability tools. These are all asset protection tools: LLCs, limited partnerships, corporations. Certain forms of these trusts that we spoke about, charitable trusts, some of these estate freezing we just spoke about, can be used as great asset protection tools. You get 2 or 3 bites at the apple because you get the tax benefit, the transfer benefit, and asset protection. Great. But when you're dealing with even asset protection trusts, there are about 14 or 17 states in the country that have domestic asset protection trust law, spendthrift trust law. Ones that come top of mind, you got Delaware, you got Nevada, South Dakota, Wyoming, Alaska, Delaware, I think Tennessee, Hawaii. These are just, and there's other ones. There's probably about 14 or so, 17 or so states that have domestic asset protection law. Now, domestically, you got a bit of a challenge, because if you take an asset that I'm in California and I put an asset into a Nevada trust for Nevada asset protection, well, we have what's called the full faith and credit clause of the US Constitution, which binds all 50 states under one union, so that a valid judgment against me in California can be domesticated in Nevada. They'll look at it and say, oh, well, that's a California judgment, and it's valid, and sister state California, full faith and credit clause, and Nevada will enforce the California judgment. That's what makes us a country. Very important piece. But now you got a conflicts of law problem. Which law governs? California has an interest in seeing its judgments enforced, and Nevada has an interest in protecting its trust assets because of its Nevada trust statutes. You see the problem there? So you got this conflict of law, but because there's a conflict of law, you don't really know exactly how it may turn out, right? You still got an unsettled issue here, but it's a legit issue. So although domestic asset protection is wonderful and it works great, and remember, the main objective of asset protection is to get you to a point of settlement, many times that complicated, that federal court stuff is just muddy enough to say, listen, let's just settle the issue because it's complicated, right? You just don't quite know, the unknown. Okay, now the big difference there now is now you throw it into an offshore jurisdiction, right? Now you're looking at Nevis, you're looking at Cayman Islands, you're looking at Panama, you're looking at the Bahamas, you're looking at the Cook Islands. Now all of a sudden things are different. You're no longer under the American system, you're under the British system, which is very different. And you have no full faith and credit clause, right? The full faith and credit clause where California, Nevada, California doesn't exist between the United States and the Cook Islands. We call it, there's no comedy of law, and it's not comedy, ha-ha. They don't respect the laws. And these jurisdictions that we use in offshore asset protection trusts, we choose them specifically because they don't enforce. There's no treaty to respect the US laws. Otherwise, why would you use that jurisdiction as an asset protection haven? So here, if you were to send your California judgment to the High Court of the Cook Islands, they look at it and say, well, that's great, but that has no weight here, no full faith and credit clause here. So you got to go to the Cook Islands, hire a lawyer in the Cook Islands, because the lawyer in California is not authorized to practice law in Cook Islands. You got to post a bond, by the way, in the Cook Islands for the inconvenience of the plaintiff the defendant to defend themselves. The costs go up dramatically because you got to have a trial on the issues in the Cook Islands. So you can't take the facts and the hearing and the evidence that won the case in California and bring it to the Cook Islands. You got to bring it there, right? You got to have another trial in the Cook Islands. Shorter statute of limitations period from 4 years down to 2 years. Different burdens of proof. We may have civilly a preponderance of the evidence, right, which is a 51%, and now you go to higher burdens beyond a reasonable doubt, which is like a criminal standard in a civil setting. no contingency fee lawyers. So here someone slips and falls in the store and the lawyer that's advertising on a big billboard says, here, no skin in the game, just hire me, I'll win, and then I'll take 30 or 40% as a fee, but no money out of your pocket, no risk. So it doesn't happen in the British system, right? You gotta pay your way. So the same person that may have won the case in the US has to now go to the foreign jurisdiction. They gotta hire the foreign attorneys. They got to pay their way up front. They got to post a bond. The laws are a little bit more narrower than the U.S. Throw it against the wall and sees what sticks. Very, very different discovery rules. Oh, and by the way, loser pays, right? So when you lose the case, you got to pay all the expenses, right? So it's a whole different ball game. And so many of my clients, we start off as a domestic structure, and we may over the years migrate them over as they become more comfortable with it to a foreign jurisdiction. Sometimes we use a combination of both. We have a domestic structure and an offshore structure, depending upon the nature and mix-up of the assets, or because of the risks that they have. They're in a risky business. They just start off with a foreign structure because they're concerned about the lawsuit can come any day, right? Any time, you know. So you set the stuff up in advance. And that's the main difference. It's really a matter of convenience versus inconvenience, time and expense, burdens of proof, cost factors for sure. And certainly an offshore structure is much, much more likely to result in a fast and favorable settlement just because of all the things I've mentioned, as opposed to the California, Nevada type of thing. And that's, it works domestically, but it's nowhere near as good as a foreign structure, right? But everyone's got different risk tolerances, so we got to talk to the client.
Watch it. Yeah. You can go on forever about this. Brad, thank you so much, and until next time.
Okay, great. Thanks, Paul.
All right.
Bye-bye.